Good day, my name is Fritzie and Tecson, and I will be discussing Lesson 12, Collective Bargaining and Labor Relations. We all know that management's function includes the planning, organizing, staffing, leading or directing, and controlling an organization. But one of the most basic decisions of a management is whether to encourage or to discourage unionization of their employees. First, we will talk about labor unions. What is labor unions? Labor unions is an organized association of the workers. It is to protect and expand their rights and their interest as an employee. If the management encourage unions, the workers will improve their well-being and get a positive employment relationship. But management may discourage unions because it fears higher wages and benefit costs, disturbances caused by strike, and barriers placed in flexibility on their judgment. Take a look in the labor relations framework. It shows typical provision negotiated by unions in collective bargaining contracts. Labor unions attempt to represent their members' interests in these decisions. If it doesn't have an adequate union representation, wages, security, and welfare of a worker can be put at risk. The National Labor Relations Commission, or NLRC, is a quasi-judicial that is mandated to promote and maintain the industrial peace, and peace can be obtained by resolving labor and management quarrel based on social justice. The NLRC is a subsequent part of the Department of Labor and Employment, or DOLE, where the policies and programs are coordinated. The Labor Code of the Philippines, which is part of Article 218 of the Revised Penal Code, has issued the NLRC the following set of rules for handling its cases. Rule number 1, Title and Construction. Only signifies the title of the governing rules. Rule number 2, Definition of terms. Defines the legal terms used in the terms and phrases defined in Article 212 of the Labor Code should be given the same meanings when used in NLRC cases. Rule number 3, Pleadings, Notices, and Appearances. Signifies that the parties involved will be given due notice for any impending proceedings. Rule number 4, Venue, Assignment, and Disposition of Cases. Advise that cases which labor arbiters will file the case in the regional arbitration branch that has jurisdiction over the workplace unless there are justifiable reasons why it should be filed elsewhere. Rule number 5, Proceedings before labor arbiters. Signifies that the labor arbiters should have exclusive jurisdiction to hear and decide all cases involving labor issues. Rule number 6, Appeals. It signifies where to submit an appeal after a case has been decided, and this area also advises both parties of the time frame given for an appeal to be submitted. Rule number 7, Proceedings before the Commission. This rule suggests that the process flow of each case proceeding from time a case is filed towards decision or further into the motion for reconsideration. Rule number 8, Execution Proceedings. Signifies the rules to take place after decisions have been done and how the winning party could claim the damages incurred. Rule number 9, Certified cases. Signifies that the NLRC cases are certified by law, and any cases which happen within the proceedings are considered final unless appeals are made. Rule number 10, Contempt. Signifies that committing any act of misbehavior in the presence of the chairman or any commissioner or labor arbiter will hereby be given an additional penalty. Rule 11, Injunction. Illustrates the injunction that may happen within a labor case. Rule number 12, Commission seal records and powers and duties of commission officials. illustrates the notices to be given, how archive may be accessed, and duties of the official and employees of NLRC. Rule number 13, effectivity, indicates that these rules are in effect 15 days after August 31, which means that these rules were officially used starting September 15 on 1990. Local unions. An important characteristic of a union is whether it is a craft union or an industrial union. Common example of craft unions are plumbers, carpenters, and musicians. Craft unions generally exert market control by limiting the number of suppliers. Industrial union is a labor union organizing method through which all workers in the same industry are organized into the same union, regardless of skill or trade, thus giving workers in one industry more leverage in bargaining in strike situations. The local union typically elects officers like president, vice, and treasurer, and they are responsible for contract negotiation. They also provide assistance for background data about the other settlements and technical advice to sending a representative to lead the negotiation. Union membership and bargaining power. For the unions to maintain their financial resources, they need to recruit union members. That's why unions have membership. After that, the union needs to organize their new members and current members to have a bargaining power and financial resources in order to achieve the goals of future contract with the management. Structural changes in economy. Before, many middle-aged men in blue-collar job are employed in many urban workplace, and in the recent job, many women and youth are in the service sector. Despite the importance of structural economics changes, study shows that their account does not exceed a quarter of the general decline in union membership, and they are not successful in organizing the group in the private sector. Increase employer resistance. Many employers resist a union membership because they know that it may be a disadvantage to them. Union can demand whatever they like and they will get a benefit from it, while in the situation of the employer, it might be their loss. So, to control their cost and flexibility on their judgment, they resist union membership. The negotiation process. Richard Walton and Robert McCarthy suggested that labor management negotiation could be broken into 4 sub-processes: sub-distributive bargaining, integrative bargaining, attitudinal structuring, and intra-organizational bargaining. In distributive bargaining, it is like a pie chart, that if a union demands high salary, it will cause the management to release an additional fund for wages. It's a win-lose situation in this kind of agreement. The union will take a large part of the pie chart, and the management will get a smaller part of the pie. In integrative bargaining, the both sides have a benefit on their agreement. Example is, if the management needs to reduce labor costs, they will reach an agreement with the union to avoid layoffs in return for union to agree with the changes of work rules, and it might enhance the productivity. In this situation, it's a win-win for the both parties. In attitudinal structuring, it refers to the relationship and trust between the management and the union. If the relationship of the union and management is poor, it will be difficult to the both sides. It is always important to the union and management to build a strong relationship to each other. In intra-organizational bargaining, it tells us that there's more than two parties involved in labor management negotiation. Management preparation for negotiation. Management first needs to establish interdepartmental contract objectives. They will meet different departments in the company. 2. They should review the old contract. 3. They should prepare and analyze the data, the information on labor cost, productivity of competitors, as well as data the union may emphasize. Number 4, anticipate union demands. Recall grievance over the previous contract having ongoing with union labors and become aware of the settlements. Number 5, establish the cost of possible contract provisions. 6, prepare for a strike. Number 7, determine strategy and logistics. Management's willingness to take a strike. Management willingness to take a strike comes down to two questions. Number 1, can the company remain profitable over the long run if it agrees to the union's demand? Number 2, can the company continue to operate in the short run despite a strike? In question number 1, the answer is most likely to be a yes to the extent that higher labor costs can be passed on to the consumers without losing the business. In number 2, the short-run concern is the loss of revenues and profits from production being disrupted. The cost to strikers is a loss of wages and possibly a permanent loss of their job. These are the conditions of the management to be able to take a strike. Number 1, product demand. Management is less able to afford a strike when the demand for its product is strong. Number 2, product perishability. A strike by certain kinds of employees will result in permanent losses of revenue, thus increasing the cost of the strike to the management. Technology. Number 3, an organization that is capital intensive is less dependent on its employees and more likely to be able to use supervisors or others as replacement. Number 4, availability of replacement workers. When jobs are scarce, replacement workers are more available. Number 5, multiple production sites and staggered contracts. Multiple sites and staggered contracts permit employers to shift production from the struck facility to facilities that, even if unionized, have contracts that expire at different times. Number 6, integrated facility. When one facility produces something that other facility needs for their products, the employer is less able to take a strike because the disruption to production goes beyond the single facility. 7, lack of substitute for the product. A strike is more costly to the employer if customers have a readily available alternative source from which to purchase goods or services the company provides. Arbitration. Arbitration is a procedure for resolving collective bargaining impasses by which an arbitrator chooses a solution to dispute. The most formal type of outside intervention is arbitration. In some instances, the arbitrator can fashion a solution. In other cases, the arbitrator must choose either the management or union's final offer. What criteria do arbitrators use to reach a decision? Is the most common case, or the following due process questions are important? Did the employee know what the rule or expectation was and what the consequences of not adhering it were? Number 2, was the rule applied in consistent and predictable way? In other words, are all employees treated the same? Number 3, are facts collected in a fair and systematic manner? Number 4, does the employee have the right to question the facts and present a defense? 5, does the employee have the right to appeal a decision? 6, is there progressive discipline? 7, are there unique mitigating circumstances? These are the following questions for our arbitrators for them to be able to decide. Strikes is a refusal to work organized by a body of employees as a form of protest, typically in an attempt to gain a concession or concessions from their employer. So most of the strikes involve white-collar employees who is a professional who work by desk. Productivity. When a union and management agree to, for example, agree to increase the wage of the worker, and the productivity of the worker will decrease and the motivation to work will become low, as they know that their salary is high and the benefit is high. Because union extend the right of a worker, management cannot put many tasks to the worker, and it may lead to lesser work being done. And because of the lesser work being done, the production of the company will slow down also. Profits and stock performance. If the management and the union agrees to the negotiation, like they will increase the salary just to get a better productivity to the worker, it will still suffer, the company will still suffer the management, because they will need to release an additional money for the salary expense and other benefit costs for the demand of the union and the worker. That's all. Thank you for listening.